Good day. This is The Law LLA, a podcast on constitutional law from the perspective of scholars of color. I'm Craig Jackson, professor of law at the Thurgood Marshall School of Law at Texas Southern University, along with my colleague Edilberto Roman, who is a professor of law at the Florida International University School of Law. Dr. Laura Cisneros, affiliated scholar at the University of San Francisco School of Law, and our special guest discussant this morning, this afternoon, this evening, whenever time you're looking at it, Professor Chandra Lewis, my colleague at the Thurgood Marshall School of Law and a scholar in Second Amendment. That should tell you where we're headed this morning. If you keep up with the slow and steady drop of decisions on the part of the court, you are aware that the only case that we thought was of any constitutional significance in a year of hugely significant court cases that dropped in the past week was this case called United States versus Hemani, a Second Amendment case about drugs. And before you start, well, it's about drugs and guns. Now, before you start thinking this is another episode of Narco, which it's not. It really is kind of a lightweight case about a guy who smokes a little marijuana and also owned a gun, which under the Second Amendment uh, is a right, and which under interpretive cases, Heller and Montgomery, McDonald versus City of Chicago, is a fundamental right. People have the right to have guns. Now, the question now is whether or not you can have those guns in the context of breaking the law when it comes down to the use of marijuana. So I guess basically, I want to start a discussion with this idea that I think we should probably start the discussion first of all with just letting the audience know that we're going to be looking at all these other cases, the cases that we've really been waiting on for the past several months when they come out. They haven't dropped yet. We're expecting them to drop probably Thursday, but we're going to start with this case because this is the only one of significance so far. A brief summary of the decision. It involves the Gun Control Act of 1969, I believe it was, in which it makes it illegal for a person to possess a gun when they are also involved in the use of controlled substances. That's kind of a quick and dirty description of the law. And the law was challenged by Hemani, who was basically an occasional marijuana smoker, and he was arrested and was in the process of being prosecuted, a prosecution that would lead to his denial of his use of or possession of a gun for the rest of his life, which he said, or his attorney said, was contrary to the Second Amendment. And that's where we stand right now. And the complicating factor in this is that we have a case precedent that kind of that supposedly describes how these Second Amendment decisions are to be made. Case called New York Rifle and Pistol Club versus Bruin, 2019 case. Am I correct on the year? 2019?
2022.
22.
2022. Boy, it's 3 years off. 2022. It says you have to use something that I've seen referred to as originalism by analogy. In other words, finding an analogous law at the time of the framing of the Second Amendment that would be similar to the law the government is defending in present day. So I'll just stop there and let anybody chime in as to what this decision. The court found that the Gun Control Act, or that portion of the Gun Control Act, was unconstitutional under the Second Amendment. And I'll stop there and let anybody who wants to chime in with their comments start.
Well, first, just by way of context, right? Before this case, you have this Bruin case.
Right.
before Bruin came out, you have Heller and McDonald that recognize this individual right, separate and apart to carry firearms, separate and apart from a militia. This individual right to carry firearms in self-defense. But what those cases did not address or acknowledge is what test do you apply when assessing whether a firearm regulation violates the Second Amendment or not. And so when Bruin came out, it clarified because the courts were divided. They were using a two-part test. So some were using a two-part test where they have this history. They look at the history of the Second Amendment, history surrounding what conduct was covered and so forth, and a combination of a in scrutiny means test, right?
Right.
And so what Bruin said, well, no, you don't use that two-step test. We're just going to look at this history, or as you call it, this originalism analogy test. We're going to look at, is there a historical analog to this modern day firearm regulation that restricted firearms in the same way that the statute that's in the present day that's being challenged.
Mm-hmm.
And so in that context, it's very hard to do this when you're looking at the history, because the history is complex and it's contradictory. And then what history are you looking at? Are we looking at the history surrounding the Second Amendment that was enacted in 1791, or are we looking at the history of the 14th Amendment in 1868? And so here comes you have Bruin, you're looking at the history, and then you have this case now, this Hemani case that's looking at the history. It appears to be the history surrounding the Second Amendment. The Second Amendment, 1791. And when you're looking at it, there was no analog. They're looking at these habitual drunkard laws. And what I found to be very interesting is I don't think this case was about firearms, but it's also about marijuana and the widely accepted usage of marijuana. And I'm wondering if the outcome would have been different if, say, it was crack. He used crack every other day, or he was a drug dealer and being investigated for that, with the outcome being different. The problem here, I think, in this case, the reason the court was unanimous in reaching the result that it did, that this violated the Second Amendment, is because they didn't show that he was dangerous. Marijuana is widely used. He didn't show that just by using marijuana that he was violent in any way, and that he couldn't safely use firearms to protect himself.
One of the things I don't understand, what I don't understand is what Thomas wrote the opinion, by the way, in Bruin, and why the change? Why are we changing over from, let's call it what it is, strict scrutiny? I mean, this is a fundamental right, Second Amendment fundamental right. We use strict scrutiny for fundamental rights. So basically, why are we changing over from strict scrutiny? That is where the judges will determine whether or not the reason for the law is necessary, is compelling, and whether or not the means of achieving that compelling interest is necessary to achieve the compelling interest. Why are we moving from that when that's how we treat all other fundamental rights? Why is Second Amendment treated differently? I never really understood why, in the opinion in Bruin, why Thomas went that direction.
So I'd love to jump in here. And Chandra, thank you so much for that context, because I think that that's super important. And as you know, Craig kind of voiced with his question, it leads to that obvious question about why was the shift. When I read this case, first of all, I appreciated that it was only 39 pages. Given multiple opinions, so thank you.
Yeah.
And second of all, the holding is easy, I think, to state, and it's easy to underread, right? A regular marijuana user cannot be automatically and permanently disarmed on the basis of that alone, right? That seems fairly straightforward. But for me, the more interesting story is methodological, because here the court tells us from Bruin that this test is about founding era tradition, right? That this is a history and tradition case that we're going to resolve. And this is what, as Craig mentioned in his question, this is when the court in Bruin substituted the ends means test the balancing test for this ostensibly objective historical evidence test. And so, but what we have though is with the identification of the history and tradition test, I think another important stepping stone between Bruin and this case is Rahimi, right? The domestic violence case about possession of firearms case that the court decided. I think was that just last term, right? That the court in Rahimi and this case kind of clarify that history and tradition test, right? Once the Second Amendment's text covers the conduct that's being challenged, then the government has the burden to show that the regulation is relevantly similar to a well-established historical analog along two axes. And Gorsuch in the majority says there's a why and a how component. Why and how equate to purpose and operation, which by any other name is ends means analysis.
Yeah.
And so for me, the methodological shell game here is that the court is leaning on the statement of a history and tradition framework test, but then they are applying a means ends analysis when they're looking at comparing contemporary practice and historical regulation through purpose and operation. And so, I think that this case, short as it is very telling about that move that the court is making.
But Thomas would have said in Bruin that the why has already been established by the people. In other words, Second Amendment says, it's the right of the people, basically. That being established, then the only thing is to determine, whether or not the law is analogous to founding era. In other words, he's saying that the judges who've been using strict scrutiny have been using one step too many to make determinations about that. But essentially, you're right. I think it was a Breyer in Bruin who says this is just means end, another way of putting it. So it seems like a lot of to do about nothing, and I guess it has to do with the idea that these are guns, and this is what for some reason guns have a mystical quality in American life that we are able to change standards of review when there's no real reason to do so.
It's almost like they're treating the Second Amendment like a super constitutional right, like it's greater than any other right, giving it a status. When you think about the Second Amendment, when they're talking about it, they say they were codifying a pre-existing right, unlike the Fourth Amendment, First Amendment, other Bill of Rights, where they're creating a new right that's different, that wasn't already recognized under English law. You're looking at the Second Amendment that always existed, right? This right to protect yourself for self-defense. And so when they're looking at it and they look at the history, and it's very interesting when you look at these opinions, they're looking at the historical evidence. It's interesting how they look at the pre-civil slavery, because when you look at it too, like there's this history of trying to disarm Black people, right? And you talk about that, and then you compare it to there's a history of them arming themselves to protect themselves, that conflicting history. And so when you selectively, and I think I saw this in a podcast that Professor Roman, was it the February 2026 podcast that you guys did, and you're talking about, you say selective originalism or something like that, when you're looking at historical evidence, that's part of the flaw with using this originalism historical test when you're trying to interpret whether a regulation has an analog, whether it violates the Second Amendment, is which history do you give heed to? And I think Thomas also, when he's talking about using this test, he points out that's one of the problems with it. And when do you give more weight to the history or not? Which history do you give more weight to? And he seems to suggest, and I'm seeing, do you agree with this interpretation, he seems to suggest that more weight should be given to the history surrounding the enactment of the Second Amendment itself, as opposed to the post enactment of the Second Amendment around the 14th Amendment, even though he recognizes there's an ongoing scholarly debate about how much weight you give to the historical evidence. Did you pick up on that when you were reading the opinion?
How much weight you give to historical evidence? Yeah, well, I mean,
Well, some of it's conflicting, right?
yeah. I mean, it's conflicting because this is the criticism of originalism generally,
Right.
not just originalism by analogy, but originalism generally. It all depends on which history you pick. I'll take that one. I'll take that one. I'll take that one. Which is called cafeteria history.
Yeah, I think
Well, that goes.
they're gonna run into, excuse me, they're gonna run into trouble with an originalism context, and this is one example, one junket into it. When you try to create an originalist framework based on what occurred at the time, and you're addressing matters that perhaps wasn't something that was a norm, such as marijuana smoking or another drug, and I think that's what Professor Lewis is alluding to in this context, and I think the term you referenced that I made is, and I often repeat it in these podcasts, of being selectively principled, right? It sounds nice, it has this principle theory with originalism is a classic example of that. But then you pick and choose when you want to use it,
Right.
and being selectively principled is not being principled.
If I
In
could,
this
I'm
instance.
sorry, if I could just maybe add to the selective originalism, selectively principled, and the which history do you pull from that Chandra was talking about to kind of open this. There was something that stuck out to me as well in this case, dealing with the question of which history gets the most significant weight. And so when the majority opinion and Gorsuch in writing it starts talking about, look, when we look around the time of the founding and for decades following it, and this is in his trying to understand what habitual drunkard meant, right? Because that's the point of connection between the contemporary law marijuana users, drug users, and habitual drunkards. And I was I was just taken by the way that the historical record and the evidentiary record is constructed in the majority. And I'll tell you why. The very first thing he points to is a statement from Dr. Benjamin Rush, who he indicates was a signer of the Declaration of Independence, who offered a description about a habitual drunkard as somebody who, really had a severe condition that they would walk in front of a cannon. I think is what is
Yeah, right.
would walk in front of a cannon to get to the keg, basically. And but then he goes through, and as I was reading the next section, it felt like a rereading of Chief Justice Taney's discussion in Dred Scott when he is breaking the analogy between the Declaration of Independence, all men are created equal, and showing why that doesn't translate to cover descendants of slaves in Dred Scott's situation. Because what he ends up doing, what Gorsuch ends up doing, is he ends up stacking a bunch of founding era people. Madison used to drink whiskey every day. Thomas Jefferson had 3 to 4 glasses of wine, and he goes on and on and on. George Washington and all is about all of these founding era people. So they couldn't possibly have meant the occasional drinker, which means they couldn't possibly have meant the occasional drug user. And I was just like, okay, you were saying that the term habitual drunkard could not possibly have reached the ordinary regular drinker because so many of the founders drank heavily. And I want to name that interpretive technology rather than the morality behind it, because it is structurally the same inference that Tawney made in the Dred Scott decision.
That's an interesting point. It seems to me that those comparisons are missing something.
Hmm.
Whether it should or shouldn't be is another question. But marijuana is still illegal under federal law. But when George Washington or any of those guys in the knee high stockings drank a whole bunch of rum before breakfast, to get themselves started. They weren't breaking any laws.
Mm-hmm.
So, to the extent that you're comparing the copious drinking of that era to, which is legal, to the illegal action of smoking occasionally, it strikes me as an improper comparison. And one of the problems I see with originalism by analogy is that it's so complex. It's hard to really tie down the analogy. Are you tying down the analogy with regard to what is covered by the Second Amendment, or are you tying down an analogy by what the present day law looks like compared to the laws in existence at the time of the framers? If
Mm-hmm.
it's the laws in existence at the time of the framers, did we consider the possibility that the framers may not have thought about certain societal issues? They sure as hell didn't think about violence against women,
Mm-hmm.
which was the issue in the Rahimi decision, which the court, fortunately, to the court's benefit and credit, did decide that laws restricting possession of weapons by men, typically men, who had had uh, restraint orders of restraint against them for spousal abuse. That rule and that law, that part of the law, is constitutional to their credit. But it wasn't an issue in those days, in the old days, because the courts and men and government undervalued the value of women, and therefore didn't care much about violence against women. And that's kind of the unfortunate history. We can go on for days about the other kinds of people that weren't cared about by the framers generation. But if you're trying to determine what's a societal problem and trying to apply that in the past, I don't see I don't see if you can do that in every situation.
Well, going back to your comment about the marijuana, the Supreme Court in the Hemani decision did make a point of recognizing how the government's position was weakened by the fact that marijuana was moved from a Schedule One drug, or at least some marijuana products. Schedule One drugs are those that have no medical use and are dangerous drugs, to a Schedule 3 that have some medicinal purposes. And the fact that there was a memorandum that they would not prosecute people who use marijuana, just to show that it was more widely used. And I think they even cited a fact that they believe, or there's some survey that shows that more people use marijuana now than they use alcohol. And so it kind of goes back to something I think that Laura referenced, and that you referenced, Craig, earlier, that the fact that so many people are using marijuana now, to say that if you use marijuana, then you lose your right to a firearm. It's
Mhm.
something that probably went into the court's reasoning here as well, because a lot of states now have legalized marijuana too. So I think the type of drug also kind of plays into the analysis here.
And I think that that's what is so interesting about this case, because Bruin, if you take Bruin at its word, it freezes the inquiry at the founding, right? Again, even in this case, the court says we're not going to choose between looking at 1791 versus 1868, right? But it essentially, we can just kind of generalize and say it freezes the inquiry at the founding. But what Hemani kind of quietly does is it quietly starts to thaw that freeze, because the government's own contemporary choices, the 2013 memorandum that you just talked about, the recent state legalization that you just talked about, the government's own contemporary choices become constitutional evidence. And it means that tradition here isn't only a fixed inheritance, it's a moving target that contemporary politics can edit.
Mm-hmm.
And so it's trying to have it both ways. When you break down the analysis, all of the things that you guys are pointing out that they're bringing in and that they're considering speaks to present behavior, right? It's the court using history to build a test and then present practice in order to resolve it. That's that's not the originalism I grew up with.
Mm-hmm. I
I think
guess.
it'll be interesting to see if they're willing to do that when the bent is on a more progressive, right?
Yeah,
Through a progressive
yeah,
lens, be it
yeah.
in terms of issues that are going to likely come up within the week, right? In terms of transgender sports,
Not going to
I
happen.
suspect we will not see that.
Yep.
I hope I'm wrong with respect to it, but and I don't know how much, Craig, you have more to address on this. But one of the things before we leave is not only to give you grief about my New York Knicks, right? Because you know I have to say it. That's why I'm wearing the T-shirt now in terms of New York, even though I'm in Miami. But nevertheless, more importantly, if we could prognosticate a little bit on next week, but I'll leave it to our fearless MC here to let me know when we should shift and to spend a couple of minutes on what you think the court will do within the week or so that it has left.
Well, I know what you think about birthright citizenship. That's it's your
Yeah, I hope it's going to come down 6-3. It might be 5-4. It should be 9-0 to uphold the right if there's an honest reading. But I think they're going to do the classic conservative um, uh, gamesmanship, right? Of saying, oh, because the last paragraph of one Kim Ark decision made all these conditions on residency the court there never addressed birthright citizenship, and every decision after that is misguided. So that's going to be, I suspect, Kavanaugh, at the very least, Kavanaugh, Alito, and Thomas will be in, I hope, in the dissent. I'm still worried about Gorsuch and Roberts, but I think Barrett is squarely with the three amigas, and I think she'll bring along Roberts and Gorsuch to uphold the constitutional right of birthright citizenship. How about transgendered rights and
well. I want to
regulations?
before you move over. I want to kind of pull in and the the originalism to birthright citizenship. If there was a case more adept to originalism than the birthright citizenship case, I don't know what it is because it is right there. You have a whole century and a half of history in terms of case precedent and also understanding. And these guys made that decision 40 years after 30 years after the 14th Amendment was issued. So basically, um, the critics of originalism are right. And whether we're talking about originalism by analogy or traditional originalism or original meaning, originalism, whatever you're talking about, it really is kind of a means by which conservative justices can come up with conservative outcomes. It's not a rigorous, as far as I can tell, it's not a rigorous means of analysis. You just pick the history you like and you go with it. And that
Right,
was never on
and that's
display
particularly
in
important
a
to
Hiller.
note. I think that's particularly important to note because they're basing it on a framework and an era, right, where a conservative school of thought was not even a debate; it was the norm, right, in terms of a host of issues like the Second Amendment, among other things. But it's a bit they run into trouble with birthright citizenship because, as you pointed out, right, well recognized in 1868 with the 14th Amendment and every Supreme Court decision thereafter. But we're going to see, at least I hope, in the eyes of the dissent, I think there'll be more than one, actually. The eyes of the dissents there. I think Thomas will write one, and I believe Alito will write a different one. They'll join each other with respect to it. We'll just have to see if how tortured their logic is going to be. But again, I blogged about it. I have a pretty exhaustive piece coming out at one of the University of Pennsylvania journals on the definition of the term subject to the jurisdiction thereof. Should have been out weeks ago, but you know how student editors are, drive me crazy. I wanted to send it to the justices, but I think it'll be an exhaustive statement with respect to this issue. There's no debate that the right was recognized. The exceptions were only in two limited contexts. One is an arcane anachronism with respect to the legal fiction and the morally bankrupt view of indigenous people that were the exception to birthright citizenship at the time, and the children of diplomats, which is still consistent today. There was never really a legitimate debate until, right, the conservative revisionists led by a host of law professors, conservative law professors, like Randy Barnett, among others, who many of whom I've debated. They have no footing other than politics, and I hope in this context, politics won't carry the day.
Oh,
Well, you know,
it may go. I'm sorry, Laura.
well, I was going to say, and I think what's interesting is like you can draw a red thread between the Hemani case that we're talking today, to what you guys have just been talking about with respect to the birthright citizenship case in terms of how originalism functions. Because in the Hemani case, we get the court rereading the purpose of old laws, right? Let's look at these historical analogs and let's figure out what the purpose of them was and see if the contemporary government action, government regulation mirrors that. And it's the same analytical process that they're going to have to go through for the birthright citizenship case, right? Let's take a look at what the situation on the ground was with respect to subject to the jurisdiction of, and see, what the purpose of that was and what evidence we're looking at in order to ground our understanding. But the thing of it is that kind of why analysis recharacterizes the analogs and the historical evidence that you're looking at. So the recharacterization is actually doing a lot of the real work and is itself a historical construction. So whoever controls the characterization of historical purpose is controlling, in Hemani, the analogy, and will be controlling the underlying purpose for subject to the jurisdiction of for the 14th Amendment. And so, I really like your breakdown of where these opinions are going to fall, and I'm really interested to see how these justices are going to justify and explain the positions that they stake out.
Well, if they go the other way on birthright, originalism will be dead. At least any rational description of originalism will basically be dead. Um, I wanted to just mention one thing about the and I mentioned it earlier going into this, but I wanted to just talk about this one more time. Uh, am I right that the whole this really comes down to, in the going back to Himani, it really comes down to whether or not the societal issue at play actually existed at the time of the framers. And we talk about specifics, the protection of women, which in the Rahimi case, the court did, like I said earlier, did find that the gun laws that prevented gun possession, people who had uh, restrictive orders against them, not being allowed to possess a gun if they had been threatening their spouse. But nobody, again, that wasn't an issue in this 18th century, unfortunately. So does that basically kill the rationale behind um, originalism by analogy? If you don't necessarily have consensus throughout time as to what a societal problem is.
Well, you remember in Bruin, in part of the opinion, it said that if there was a societal problem that existed during that time, and there was not a firearm regulation that dealt with that issue. So I'll give an example. In Bruin, they tried to use the example of if there's a highly populated area, and because of that, that would be a reason to not allow carrying guns in public. And if there was no regulation prohibiting that, then you couldn't use that societal problem now, today, to justify prohibiting carrying guns in public. That would be evidence that you could not justify that regulation now. So,
But there were no dense populations in those days.
right, there were no discoveries. But that
Well,
just shows you how they use it. So that goes to, or could be used to address your question of, if there's a societal issue that exists or didn't exist, how do you deal with that? And so, in that opinion, didn't Bruin also address how do you deal with a situation if it's ambiguous? If there was a societal issue that either there's no evidence or the historical evidence is ambiguous, it's unclear whether it existed or not. How do you deal with that in modern time?
Hmm.
What do you use? And I don't think they really clearly gave us a metric to use. Like, I think in that case, it would lean toward finding, if you find that the regulation covers conduct that's clearly protected by the Second Amendment, I think the scales will tip in favor of the defendant's right that is protected. The Second Amendment protects their right to keep the firearm, right?
Right.
That's just my opinion on
Yeah,
that.
I think your hypothetical is well put in that it highlights a vexing problem of originalism,
Mm-hmm.
right? Of the scenario or context
Mm-hmm.
where the issue wasn't addressed, and then they'll struggle.
Mm-hmm.
And I think you hit the nail on the head.
Mm-hmm.
They'll resort back to their you know overall recognition or lack thereof, depending on the context, in light of what they believe would have occurred. But I think that, if nothing else, from a logical standpoint, kind of highlights the fallacy of
Mm-hmm.
that jurisprudential framework,
Mm-hmm.
as being guesswork. And that's why I think where it fails or falls.
I think absolutely, and I think that that's one of the reasons that lack in Bruin is one of the reasons why in Rahimi they had to talk about, look, we're not talking about a historical twin, we're talking about principles.
Mhm.
And that gives them the space to move because there are so many contemporary situations for which there is no practical historical analog. Like it just
Right.
didn't happen or didn't occur and manifest in that same way. So I think that's why the court in Rahimi gravitated toward, we mean principles, which again means looking at the purposes of the laws and the purposes of the contemporary laws. And so, just by example, the government was trying to make the analogy among, what was it, vagrancy laws and civil commitment laws and
Mhm.
surety of good behavior laws. And the majority under Gorsuch here says, well, vagrancy was about, social expectation and an individual being able to contribute to society. Civil commitment were, trying to protect not only the individual's financial estate, but also the financial situation of their family so that their drinking didn't, you know, um, take out all the money from the coffers, and that the surety of good behavior was really about not creating a scandal. So there are all these like morality purposes that the court reads these historical regulations and kind of glosses them with this morality. But it is just as easy to read all three of those laws as vagrancy as harm to oneself, civil commitment as harm to oneself or to others, and the
Mhm.
surety of good behavior, where you had to post money in case you did something that damage to property. All of those things falling under a plausible analog to the government's argument that the reason for the contemporary federal regulation was to protect the public against the potential for violence, for gun violence. So again, it's all in how you read it, and I think you guys are right that originalism has opened itself up to that same subjective analysis that they were critiquing in the 80s.
Yeah, I was going to talk about it. It sounds like means and sounds like strict scrutiny. It's at some level. Uh, but let me just try to follow up a little bit on Gorsuch's reasoning here. Um, Marijuana really is no big deal anymore. It really isn't. But when the Gun Control Act was enacted, it was a big deal. You can go to jail. You can do some serious time for a joint in the
Mhm.
1960s and the 1970s. Serious time, unless you're in Austin, of course. But
Or San Francisco, I would imagine.
San Francisco, right? But it's not a big deal anymore, and it isn't comparable laws. This law is in particular as it applies. There we go with as it applies to people who smoke marijuana every other day, which was the case with Hemani in this case. So, is there some value in that kind of and use of originalism by analog, or is it all just subject to our liberal progressive, speak for myself, liberal progressive criticism of originalism? You might want to bite on that one. I mean, maybe in this case it's fair to say that there really wasn't anything that is comparable.
Well, unless anybody else wants to go, I think that that's kind of the point of Alito and Kagan's concurrence, right? Because they are narrowly.
And can you repeat that again? Alito and Kagan's concurrence.
Yes, I didn't stutter. I meant to say Alito and Kagan, and I think that that's the point of their concurrence, right? That their distinctive kind of contribution is that they are affirming the court's ruling here on the mismatch alone, right? On the fact that the incapacitation point that they read from the kind of historical regulations doesn't match up with marijuana and doesn't match up with occasional drug use and those kinds of so they're kind of taking the court at its word at looking for what that original public meaning meant and does that map onto what the contemporary federal regulation is, but they kind of reject everything else and say, look, that's the one thing we're doing because that is, if you take originalism at its word, that is the one kind of justifiable operative point. Well, we're going to look back and see what the purported purpose of as told to us through the historical evidence is. But they don't go any further with that. And so, take of that what you will, but I think that their concurrence is something that is kind of trying to respond to the question that you were just asking.
Mhm. One other question, and then we can look at what's to come. Anybody want to talk about Thomas's concurrence in this case?
Oh, the Commerce Clause.
It's like, come on, man.
It's obsession.
Oh, he has been beating that drum for
Yeah,
decades.
that,
Decades.
going all the way back to the Lopez decision in 1996.
Yeah.
Yeah.
Although I will mention one thing that struck me from Thomas's opinion, because again, the argument that anybody who's read a Commerce Clause case with Thomas on the bench is familiar with this argument. But to me, the thing that stood out is one, he's making claims about what the court said and citing to his dissents and his concurrences.
Does it all the time.
My understanding, that's not the court, that is you on the court.
Right.
But after doing that, he has this big long paragraph about lower court, circuit court judges who agree with his position, agree with his reasoning. And I'm like, why are we putting that in? Is it to potentially signal potential, future Supreme Court nominees who have a conservative brand and a conservative philosophy on some of these issues? Because it was just a laundry list of circuit court judges who held that same position, and I just thought that was interesting.
Yeah, yeah. Basically, he's been holding this, trying to make this point for quite some time, and essentially, it's kind of a mercantilist view about what commerce is and what it's not, and it's nobody's accepted it at all but him, which is interesting. Well, cases coming up. What's the biggest one we talked about already? That's the birthright citizenship. Is that the biggest one, really, though?
Yeah, I think so. I mean, there are other consequential ones, but I think birthright, depending on how it, how it turns, right? If it's decided the way it should be, it's going to be a yarner. This is nothing new. Courts consistently held this, recognized this right for over a century and a quarter now. But if they go the opposite way, then everything turns on its head, including the point you made earlier, the jurisprudential frameworks that they were alluding to, and then it's pure politics. the nine, not justices, the nine politicians on the court. Let's call it what it is. I can't do it to my first years because they have to prepare for the bar exam, but it's going to be difficult to teach a course where the courts are not going to care about the Constitution. But the other ones I think are of some moment. You want to mention them, Craig?
What's that again?
You want to mention the other ones that we'll likely see next week?
Well, I have to
The
look at my
issue.
list, but I think transgender
Mhm.
athletes
Mm-hmm,
case
mm-hmm.
is one that's coming up, and there are a few cases. Uh, a few cases having to do, I think, with what one case that hasn't come up yet. I have to look at my list to make sure because I have a list of upcoming cases that I'm waiting on, but I just don't recall them right now.
So I'll just throw in a couple. There's Watson versus Republican National Committee, which is about mail-in ballot deadlines. There is the Trump v. Slaughter,
That's
and
the one. That's
right,
yeah.
the Humphreys executor, whether that's going to withstand or be overruled.
You
And
know it
then
will be right.
and then there's the temporary protected status cases, Mullen versus Doe and Trump v. Mio, that they all kind of have this theme of who does the Constitution continue to protect? Who belongs under that protection? It's all about including or excluding certain people.
Yeah.
Right, and in the case involving the presidential power to fire that you
Hmm.
mentioned, we know where that's going to go.
Right.
We know where that's
Yeah,
going to
I think
go.
all three will go conservative. I
Huh?
think protective status, temporary protective status, is gonna be a punt to the presidency on the foreign relations, war-related justification that we saw throughout the latter
Yeah,
part of the 20th century. The transgendered rights issue, the regulation will be upheld. I think largely on political grounds, and the lack of a great deal of jurisprudence to support these rights, unfortunately, with a conservative court. And the overall and in terms of the other ones, the recognition of supreme executive power, for lack of a better
right,
way.
right.
Right.
But this is a unitary executive court.
Exactly.
At least six of them, other members of the court, and in the temporary protective status case, they'll be citing all kinds of decisions like Trump versus Hawaii and other cases because those are cases that basically stand for the basic proposition, that what the president says goes, and
Yeah,
they sure as
correctly.
hell didn't bathe themselves in a sea of glory with the Trump versus United States 2 years ago.
Yeah, they made some cases with a due process argument. People have been begging them, particularly immigration scholars, for 20, 30 years now, and it just has never developed. Bobadine gives some footing with respect to that, but there's enough differences and related to habeas corpus. They're just not present in the TPS. So I think TPS is done with by virtue of the recognition of the president's unitary power, as you correctly pointed out.
Right. Okay. Well, so and then of course the firing case you mentioned that one. That's going the president's way also, right?
Mhm. Yeah, I think so.
So is anybody going to call Kalshi and make a bet? No, I'm just kidding. Uh,
Yeah, I should. I should. But
okay.
some systems are what they
Listen, thank you so much, Chandra, for joining us today and giving us your thoughts on your issue, which you're one of the leading scholars in Second Amendment rights in the country, and we're honored to have you to join us and kind of clear up some things for us. Um, and you did better than Thomas did in Bruin. So congratulations. So,
I don't know about that, but it was my pleasure to be among you constitutional scholars. I would love to sit in one of your classes. I'm sure it is amazing. It's good to see some of you. Some of you. No, I'm just joking. I'm teasing Craig there.
Yeah,
He's my neighbor across the hall.
Oh, you should join us again without question. And
yeah,
it's a
Absolutely.
pleasure to learn from you.
yeah, exactly,
So I hope
exactly.
you're with us in the future.
Oh,
And we want a whole hour talking to Eddie Berto at once mentioning the Knicks until just
oh
now.
wow.
Well, I wanted to end with Nixon 5, but you beat me to it.
Congratulations. Okay, well, listen, we will be back shortly in the next few days, probably, because this is the week where everything is supposed to go to blow up. And I have a casebook that I have to get supplements turned into the publisher sometime in July. And if all the cases that are coming out come out this,
Here's a question that I don't know the answer. I honestly don't in this context. I can't conceive of a way these issues are not going to be resolved within the week. Can anyone?
you don't see them. You don't see them resolving all of them.
No, I can't conceive of a way in which they're not resolved
Mm.
within the week. They have to be.
They can go into July.
Yeah, oh, yeah, this summer. But how much further than that? I
They
don't. What would be the justification for the next term?
they want to get out of the country.
Yeah, that's what I'm saying. So I think we're going to hear it soon.
Yeah, so whatever they decide on birthright citizenship, they'll have to get out of the country because they may be be
Well, I
criticized
can't wait to hear
heavily
from the
by the
president.
left, or if it goes the other way, criticized heavily by the president.
Yeah,
So
I can't imagine they're gonna go the wrong way on it.
mhm,
But we're gonna hear a lot from the president, and
Mhm.
he's been having a few tough weeks with, the Iran war, the
yeah,
never-ending references of the of the of what we're gonna call it, the swamp or the pool
Yeah.
or what these days.
Yeah.
Just don't
Reflection.
walk near it, don't touch it. That's what evidently. So after birthright citizenship comes up on. He's going to go after all of them.
yeah,
Other than his three, I suspect three. It might be four.
yeah.
But if I'm wrong and they overturn it, then we have a whole season to talk about how jurisprudential movements mean nothing if they don't recognize the right.
Well, thanks for coming together today, and we'll see you in a few days, and we'll talk about the remaining cases over the next several weeks. Talk to you. Take care. This
All
is
right.
the Law LLA, and please stay tuned.